National Taxpayers Union is a nonpartisan, nonprofit citizen group founded back in 1969. We've been involved in issues not only relating to taxes directly, but other types of regulations and edicts and mandates that can function like taxes and in that way affect taxpayers. We've been involved in the antitrust battles of the 1990s, the Visa MasterCard case, the Microsoft case in 2009, the Google case. That's where we are coming to our concerns over the Federal Trade Commission. My other guests here, of course, have many other types of concerns, which we will get into in depth. Before we do that, I'd like to introduce our keynote kickoff speaker, Senator Jeff Flake, and we are truly honored to have him here. Senator Flake bears the true distinction of being a record setter on National Taxpayers Union's annual rating of Congress. That's based on every single roll call vote affecting taxpayers, hundreds of votes a year, and as a House member, Senator Flake scored #1, top position, 8 consecutive years in a row, literally on hundreds of votes a year. An incredible achievement, one that is not likely to be exceeded anytime soon. He was the #1 scorer on our rating in the Senate as well during his first year. He is chair of the Subcommittee on Privacy, Technology, and the Law right now, so very fitting speaker to kick off our event. So I would like to welcome Senator Flake. Thank you. Would you like to stand?
Sure, I'll just stand.
Yeah.
All right.
That's all right.
Here you are, sir.
Well, no, I appreciate it.
That's on.
It's on? Okay.
Should be. Let's try that again.
Yeah, FTC is doing something here.
Yes. There you go. Have a volume?
No, I can talk loud enough.
Well,
Okay.
Small enough
This
room.
for you.
Well, I appreciate it. Appreciate being here. Appreciate NTU and all the good work that's done by this organization. It really, there are a lot of scorecards out there and a lot of lists, but NTU is different. They take every vote that's cast, not cherry picking which ones to affect taxpayers and spending. And so to rank high with NTU is a big deal in my book. And so I appreciate the good work that's done. There's a lot of talk in Washington, certainly in the House and Senate, about Mission Creep, about what the agencies, directions they go. We will authorize legislation, or pass legislation which authorize certain programs, but then often the agencies just run with it and go far beyond what the Congress intended. Part of that is Congress's fault, because we tend to allow the agencies to go on without authorization sometimes. And we haven't gone through what's called regular order for years now. A regular order is the process whereby you pass appropriations bills one by one, 12 of them, funding the various agencies. And typically that's how we rein in the agencies. And that's how we tell the EPA, this is what you can do, this is what you can't do, here's funding tied to this. Just to give you one example, the EPA, I testified on legislation that I've introduced called the CLEAR Act, which will force the EPA to finally establish a rule with regard to so-called exceptional events. In Arizona, we have a few dust storms that come through. My family's been in Arizona for about 150-some years. Back to 1878, long before Arizona was a state. There were dust storms then, there are dust storms now. There'll be dust storms long after my family is gone. But the EPA treats those as if those are somehow man-made, and that increases the PM10 level particulates, and then it counts against the state, and we're in non-compliance. And for the state and local governments to convince the EPA But no, that was a dust storm. It takes about $675,000 every time one happens, and over 700 man-hours just to convince the EPA to take a look at that in the context of what it really was. That's an example of an agency going beyond its authority. It's an example of mission creep. We've seen other examples, certainly with the IRS going in, trying to judge nonprofits, and certainly going after conservatives. We see it in all other areas. And here, we're seeing it with the FTC. I was out in Silicon Valley last week, and then in San Francisco as well, meeting with tech companies. And just to story after story about here's innovation that can happen if it weren't for agencies simply through bureaucracy or mission creep taking areas. One example is with drones. There's a great budding commercial industry there, but the FAA has said, no, the only acceptable use of a commercial drone is within line of sight and with a ceiling of 500 feet. Even if you're out in the middle of rural northern Arizona, where there's not a person or a community or anything else, it doesn't matter. They have these firm fixed rules, and as a consequence, countries like France, who have a more permissive regulatory environment, are making advances that we simply can't make because the agencies won't let these companies doing it. With the FTC, certainly for them to weigh in and try to find an optimal privacy standard that works is beyond them, particularly it is beyond their institutional competence to do so. These are areas that we've had hearings on, and we've addressed. That's what ought to happen, is you have a fulsome debate and bring in experts to say, all right, here's what we ought to be doing, here's the economic costs, and put it in the context of all of these things, not just what one particular agency wants to do to increase its authority. So privacy, as I mentioned, it is a relevant topic, but it's far too important to settle by an agency that is right on the outer realm of certainly its institutional competence and its mandate. So the discussion you're having today is important, exposing and shedding light on this process, and hopefully we can make some progress here. This problem of ever-expanding bureaucracy is one that we'll continually fight in Washington, because that's the nature of federal bureaucracies. The Congress needs to take a far more assertive role than we've had over the past several years to rein in these federal agencies by, one, authorizing programs, and then two, using the appropriations process, power of the purse, to rein in those agencies when they move beyond their scope of authority and certainly their scope of institutional competence. So anyway, thank you for doing this, and glad to be here to kick it off. So
Thank you.
Thanks for what you do. Appreciate it. Wish I could stay. Discussion. All right, take care.
Excellent start to the panel. It would be really easy for us to do just a series of 4 lectures here and have you raise your hands and ask a few meat questions. What we're going to actually do is try to have a discussion whereby we will interact and explore some of the most important issues surrounding FTC and perhaps develop some reforms that we think would be high level as well as near term, intermediate in the form of legislation. Before we get into the discussion, let me just introduce the panelists here. All the way on the far left, positionally, not ideologically, is Ryan Radia. Now, Ryan's the Associate Director of Technology Studies at Competitive Enterprise Institute. You can, of course, read the official biographies of the speakers, but let me just point out that every one of these folks here has earned a JD, except for me. They've been involved in litigation as well as giving legal advice in matters directly before the Federal Trade Commission. They have informed a great deal of the recommendations in the paper that is just being released today by National Taxpayers Union. You have a copy of it. It's this right here, FTC, a three-letter way to spell nanny. Please take a look at that after the panel. Ryan has been published in a number of news outlets. He blogs on the Technology Liberation Front blog. He's also, yes, he's also an expert at areas of telecommunications law. He's going to talk about the intersection of the FCC as well as the FTC and what that means for our economic liberties. Baron Soka next here. He is president of Tech Freedom. He has been involved in a great deal of cases now before the FTC, including the Wyndham Hotels case, which we will be discussing in depth as an example of FTC overreach. James C. Cooper is a professor at George Mason University. He has recently published this paper that you have among the handouts, The Perils of Excessive Discretion, the Elusive Meaning of Unfairness in Section 5 of the FTC Act. This is a central question we're going to explore during this discussion. He is also the author of the editor of a fantastic history of the FTC. It's called The Regulatory Revolution at FTC, a 30-Year Perspective. I've read that cover to cover. I would highly recommend it. So let us begin the discussion with a little background, James, about the FTC's history in the 1970s and some of the reform efforts that were undertaken during the Reagan administration.
Yeah, sure. Thanks, Pete. Glad to be here and talk about one of my favorite topics, the FTC. And thanks for being one of the 4 people who bought my book. So, so the FTC is a little over 100 years old now. It's just as a way, I just want to give kind of a 5-minute primer on where it started and some of the troubles that it got into to set the stage for today. So it was established in 1914 with this broad mandate to police unfair methods of competition and unfair and deceptive acts and practices. Now, being a little floppy there, those who may be experts would know that the second part came about with the Wheeler-Lee amendments in 1938. Anyway, but so basically that's the FTC's mandate. This really broad, unfair and deceptive acts and practices. And what that boils down to is that they have both an antitrust side, which is the unfair methods of competition, and a consumer protection side, which is the unfair and deceptive acts and practices. So the FTC houses they have two missions within the same building. Now, with such a vague and potentially elastic statutory mandate, it wouldn't be surprising that they overreached a little. And in the 60s and especially the 70s, they began to really overreach and get into some trouble. They were using their unfair methods of competition authority, their antitrust authority, to try to restructure the breakfast cereal industry, to try to restructure the automobile industry. On the consumer protection side, they were going after really trivial matters in deception. For instance, Tim Uris, who's former chairman and long history at FTC, tells a story that there's a Geritol commercial where at the end of the Geritol commercial, somebody says, I feel Geritol's a vitamin. It's not around anymore. I don't know, but it's like, I feel alive. Ask my wife, and the wife smiles and they hug, and they're actually thinking about suing Geritol for making an implied claim of marital bliss if you take, and that's apparently a true story, not something not apocryphal. And where they've probably gotten the most trouble is they're trying to expand their unfairness authority in consumer protection was the so-called kid bid episode, which is when they attempted to use their unfairness authority to ban advertising to children in order to save their teeth. So the idea was that there are all these sugary breakfast cereal advertisements on Saturday morning. Kids are eating too much of them, they're getting too many cavities, so we need to ban, we need to use our unfairness authority. There were the chairman at the time, Chairman Perchuk at the time, had also talked about, it had never come to fruition, using unfairness authority for this broad, to go after environmental harms, social harms, things like that. So the bottom line is they're really pushing the outer boundaries, and not surprisingly, it ended up in some congressional review. In fact, the agency was officially shut down for about, I don't know, about a week. They did not have funding. This coincided at the same time with the election of Ronald Reagan, who put in charge of the FTC Jim Miller, who's an economist and a lawyer, and he brought in a team of a real top-notch law and economics type people to put an economic structure on the FTC to make economics front and center. The book that I edited has a lot to do with that whole, that's what's called the regulatory revolution, that time period. So what came out of that is the two really important documents, the unfairness statement, in which the FTC kind of tied their hands on unfairness, this broad mandate to go after unfair methods or unfair acts and practices. They said, we're essentially going to perform a cost-benefit test. I won't go into the details of it, but there's got to be some evidence or likelihood of substantial consumer harm. Okay, that's the so this was a state, and it's going to be not outweighed by countervailing benefits to consumers or competition. And so they tied their hands with this, and they said, okay, we're now going to be bound by this. We're going to look for harm in our consumer protection unfairness cases. They also issued a couple years later, in '83 or '84, I believe, the deception statement, which again said, instead of going after these trivial claims like the Geritol thing, we're going to again anchor our policy in harm, in this notion of harm, not directly, but in this conception of what's called materiality. So there has to be a claim. The claim has to be false. You have to make a false claim, but that false claim has to be material, meaning, for those non-lawyers in the crowd, I mean, materiality essentially means that it's got to have changed your behavior. So, but for this lie, I wouldn't have bought the product. It's really easy to think about materiality. Someone puts a diet pill out, says, you don't have to exercise, you don't have to do anything, take this pill and you lose 30 pounds. Okay, so the only reason I buy this pill is for that claim. The claim's false, that's material. Where we'll talk about a little later, where materiality, it seems that in the modern FTC, in sort of tech area, especially a recent case called Nomi, the idea of materiality seems to be going into the background. So what was going on in the '80s was this big shift in their consumer protection mission to harm. Now, let me also just quickly say something about antitrust at that time period. So antitrust Section 5, again, is fairly elastic, and they were trying to push it out to, as I said, restructure automobile, breakfast cereal industry. If they were bringing a lot of cases for unilateral action that would not be covered under the Sherman Act, they suffered a series of appellate court defeats in the '80s, which led them to sort of retrench and say, okay, you know what, we're just going to enforce we have this vague, broad antitrust mandate, but rather than try to push the boundaries, we're just going to retreat. We're going to stick basically within the four corners of the antitrust laws. Now, there are one area where we'll talk about, there were a couple areas where they pushed out, and more recently they've been using, and that's why we're here, I think, to talk about it, they've been trying to kind of unretrench, if that's a word. Just trench, yes, they're trying to trench, I don't know. They're moving, they've hinted at least at using this authority to try to be a little more elastic, to move out a little more. So that kind of sets the stage. I just also want to say one more thing about the structure of the FTC, just to lay this, because I think it'll be germane to some of the things you're talking about. And so the FTC, it's 5 commissioners, 3 from the majority party, 2 from the minority party. That's how it's set up. What makes the FTC say distinct from the Department of Justice is, there are 3 bureaus. The Bureau of Consumer Protection. Those are the ones who do the fraud, deception, and fairness cases. There's the Bureau of Competition. They're the ones who bring the antitrust cases. And then there's the Bureau of Economics, which I think kind of makes the FTC pretty special. It's, I think, last count, 80 to 85 PhD economists who support both of these missions. And as we'll talk about in more detail, most of their support goes to the competition side, which runs much more smoothly and probably has a lot fewer problems than the consumer protection side. So the point here is that you know, the other thing is they have a really, unlike say DOJ, they were set up to have a very large research function. Okay, they do reports. They're set up to do that, and they also have this special power called the 6B subpoena power. So if they want to do a big study, they can actually subpoena parties to get the data. It's not that easy. I mean, there are hoops they have to jump through, but they can actually get data from parties to do reports. So I could go on, but I will turn it over to Pete. But that's just a little background.
I'd like to let everyone know, if you have questions during the discussion, please don't wait. Raise your hand. We'll take a break. We'll do our best to answer them. Now, when we're talking about a particular trend at FTC, I think we were discussing this prior to the panel, there's a need to focus on results and outcomes rather than outputs. The difference, for example, and Jim Miller recounted this, was that the Bureau of the Census was evaluating FTC's productivity in the 70s based on the number of cases initiated per employee at FTC. They were basically rating them on litigation output. That's not really a valuable measurement. That's something we had to get away from in the 1980s. It's something we have to get away from now. But Baron, talk about the consumer and competition advocacy side of FTC and what the problems are surrounding it, where it can do better.
Sure. So let me preface this by saying two things. So one, we didn't include this today, but I would recommend to you the 39-page report that we at the FTC Technology Reform Project put out in December 2013, laying out questions and frameworks on how to think about the agency. That's an initial report. It doesn't purport to offer answers. That's a follow-up project of this reform project that includes a number of scholars, including James and veterans of the agency, and you can expect to see more from us at Tech Freedom and our sister organization, the International Center for Law and Economics, steering that larger group of scholars in the coming months. So there'll be a series of essays and recommendations. So that's point number one. Point number two would be, I should preface everything I say today by defending the agency and saying a good word about it before we start anything else, which is, I think the agency is fundamentally the right model for an agency. That is to say, it is a general purpose regulator rather than being industry specific, and one that I think is vastly preferable to the specialty regulatory agencies that are left over from the New Deal. I would very much like to see, and one of my pieces of my life work is to see that the Federal Communications Commission is dismantled and its functions rearranged, and that means transferring consumer protection and competition functions to the Federal Trade Commission. So sometimes people ask me when I criticize the FTC, they say, well, but don't you prefer the FTC as a model to the FCC? And my answer is yes, absolutely. And that's why I care so much about trying to fix it. And I think it actually can be fixed, unlike the Federal Communications Commission, which I think is fundamentally the wrong model, the wrong standards. I also think the FTC has fundamentally the right standards. The basic standards of unfairness and deception are in principle quite sound. And if you read the policy statements of both of those, I might quibble about a few things on the margins, but on the whole, I probably wouldn't change a word. My critique today is really to say that the agency has not really lived up to those standards, has not done what Congress intended. My criticism would begin with what happened in 1980, which was two things. One, the Congress it modified the rulemaking authority that it gave the agency in 1975. It had previously been unclear what the agency's rulemaking authority was, and that prompted the agency to start making rules on its own. Congress gave the rulemaking authority in Mag Moss in 1975 that caused the agency to start doing even more rulemaking. And finally, in 1980, Congress decided that they needed to impose procedural safeguards. They made Mag Moss rulemaking more difficult to the point where almost everyone today believes the FTC does not have rulemaking authority, which is not true. They do, they just decide not to use it. We can have a discussion about whether that could potentially be modified on the margins, but on the whole, that was done for good reasons. The second thing that Congress did, and James alluded to this in 1980, was to force the FTC to issue a policy statement defining unfairness and what the prongs of that were. And Congress memorialized that back in 1994, which, by the way, is the last time that Congress really did anything substantive regarding the FTC. It's the last time that Congress reauthorized the agency, to the point that Senator Flake was making. After that, 1983, the FTC volunteered its deception policy statement. But my point on the highest level is that since those two things happened, those policy statements, let's say the rigor with which the agency approaches them has depended entirely on politics, on who the chairman is at the time and what their approach is, because the agency's been able to avoid actually litigating about those. So here I would suggest that there are three models of regulation, fundamentally. So there's the regulatory traditional rulemaking model. That's the one that the FCC mostly does. The FTC does it a little bit with some areas where Congress has given it specific authority. But that is the model that most people think of when they think of regulation. And it's a model that is particularly ill-suited to fast-changing technology. So for example, there's a pretty wide consensus that applying that model to, for instance, data security or privacy would not be a good idea across the political spectrum. Then the question is, well, if you're not going to do that, what do you do? And most people understand that the alternative is case-by-case approaches. But I would suggest that there are two fundamentally different ways that works. So the good way that works is what I would call the evolutionary model of law, which would be, for example, an antitrust. Over time, you go back and forth with the courts, you lose some cases, the courts require analytical rigor, economics plays a major role in shaping doctrine, and ultimately doctrine is pushed by the agency. The agencies, in fact both of them, DOJ as well, have a role in deciding what the law should be, and they do a lot of research, especially at the FTC. And James did mention this, but it's worth noting the FTC has the largest think tank of economists in the federal government, or at least the best. Bureau of Labor Statistics has a lot of good number crunchers, but the FTC has the really smart people who think about how to weigh competition law, right? But fundamentally, it's the courts that ultimately constrain the agency's discretion. So that's one model of case-by-case enforcement. The other model of case-by-case enforcement is the one that the other side of the House uses. The Bureau of Competition, not necessarily by intention, not necessarily because they think this is a better model, but because that's how it's played out, has developed what I would call the discretionary model. And it looks a lot like the evolutionary model. It's case by case. The fundamental difference is it's not just the case that the agency frequently settles, it always settles. There are no cases that actually rein in the agency's discretion. So as a result, here we are. I was born in 1980. The unfairness policy statement was born in 1980. And we don't really know much more about it today than we did back in 1980. What little we know is because Congress added 3 sentences to Section 5 back in 1994, one of which very slightly curtails the unfairness statement. But otherwise, all we really have to go on are the policy statements, and then what the FTC has taken to calling their common law of consent decrees. And that, on my mind, is not a common law. It doesn't contain the essential feature of a common law, which is going to court and having the court make decisions about whether you've actually taken the factors of your policies, your underlying legal authority, seriously. And there are a few reasons for that, but just briefly I would say that they're twofold. One is policy statements are just that, they're policy statements. They don't mean anything. The agency can revoke them overnight. The agency has done that. That's what happened to the disgorgement policy statement, which used to dictate how the agency would do damages in competition cases. That disappeared overnight with no process several years ago. But even the policy statements that are on the books, which could be revoked at any time, are not actually binding upon the agency. And the agency made that quite explicit back in 1999 in the Touchstone case, where the agency said that the deception policy statement is not binding on the agency. They can always go beyond it. It is merely a way for them to shape some of what they do. Now, for the most part, they've paid lip service to it, but I would suggest that they've actually not taken it very seriously, either of those statements. And we can get into more details about exactly why a little later, but the fundamental point is that they don't have to, because if they settle, even in a settlement, they're not actually even purporting to weigh the factors of those 2 policy statements, because all that Congress actually required in Section 5 is when they settle a case, there is no legal standard for that, unless they're seeking monetary penalties, which they generally can't do for a first-time violation. They can only do it for a violation of the consent decree. What they're doing when they settle a case, when you look at the things the FTC says are supposed to provide guidance, all those are is the agency saying, well, under Section 5B, we have to decide whether we're bringing an investigation, and all that requires us to do is decide whether we have reason to believe a violation occurred, which is a pretty low standard. It's something like an indictment in perhaps in criminal law, and that we believe that the investigation, not the settlement, would be in the public interest. There's no standard for settlement. So even if you thought that the agency, that there was some way to get guidance out of those documents, they're not even going very far. And it's only on the margins, in the rare cases where you see commissioners dissenting, which has really only happened in 2 periods since then, which has been in the late 90s, there were a number of dissents from Commissioner Orson Swindell and Commissioner Leary, and then more recently from Commissioner Wright, and in some cases from Commissioner Olhausen. Only in that limited number of cases do you actually see anything that roughly approaches the core dynamic of common law, which is 2 sides arguing about whether the agency got it right, and the majority right now just falls back on, all we have to do is satisfy 5B, the company wants to settle, we're done. So that's problem number 1. And then problem number 2, and this is where I'll stop and we can unpack whatever you want to unpack, Pete. Problem number 2 is the agency, so it goes through that settlement process. Well, the question is, well, why do companies just settle? Why is it the case that in antitrust, yes, most cases settle, the vast majority of cases settle, but you get courts deciding some cases and making decisions about doctrine. Why is it that here you get no cases where that's actually happening until at least the recently litigated cases of Wyndham and LabMD? And I would suggest that the problem lies in understanding fundamentally the litigation process. So it's everything that I just mentioned about the uncertainty of the law, which, as you can imagine, makes you as a company reluctant to fight the agency. But it also has to do with the way that the agency handles investigations and settlements. And that gets into some very, very seemingly unimportant dynamics about how the civil investigative demand process works. Because here, unlike doing litigation, say if you're the Department of Justice and you go sue in federal court and then you get discovery, here the agency has its own discovery powers. They get to do that before they ever file any complaint. So what happens is they go through that process, they bleed companies dry or make it clear to them that if they want the whole thing to end, they can just settle at any time. And Wyndham, for instance, has said in its court filings, they spent $5 million just on that discovery process, not even counting the time and distraction of the agency's, the company's management, or the PR costs to the company. It's not hard to understand why Wyndham was the first company out of roughly 50 or 60 to go through data security enforcement actions that finally wanted to sue. So I think the answer will impact this to these problems and to changing the agency's model and putting it on that more of that evolutionary case-by-case model really lies in going after both those things, making more clear the substantive standards and reforming the agency's litigation processes.
Yeah, let's unpack with the Wyndham case, because I think it's illustrative of some of these problems, because basically, as I understand it, you're not able to appear before a really independent adjudicator until you can get to the point where you're in the Court of Appeals to go after.
It's worth pointing out the FTC has the discretion to either pursue a case in its administrative court for its administrative law judge, or to bring the case in federal court. And in LabMD, they decided to, these are 2 data security cases. In LabMD, they decided to bring the case before the ALJ. In the Wyndham case, they decided to bring it in federal court. It's up to them to do that. But it's certainly true that LabMD faces the prospect of having to spend a long time litigating. And at best, it's going to take, I'm told, 9 months to litigate before the ALJ, and then you go to the full commission, which would review the ALJ decision.
Right.
And only then, after that process, then to your point, would you have recourse in an independent federal court where maybe you have a better chance of winning.
So these are both privacy-related cases connected to, I assume, the 2012 privacy report that FTC published and claims to be guidance, even though it's not really guidance. We have 2 cases here, Wyndham, LabMD. Let's unpack Wyndham first. That's the one that you filed a friend of the court brief in. Wyndham Hotels, 3 data breaches. The FTC is essentially saying you should have known and should have taken precautions to safeguard the data and have remedies. You didn't do it, so now you're under the gun. What are the central issues there, and why is this important?
So in some ways, Wyndham's an unremarkable case. Wyndham pretty clearly had not great data security. We probably all want them to do better. And it left them vulnerable to being the victims of Russian hackers. The question, though, is how much better should they have done, and what should the legal standard be? And the agency brought an enforcement action essentially saying the company, had failed to have reasonable data security and should have done all sorts of things, some of which the agency had alluded to in its privacy report. Wyndham argues that the agency's never provided fair notice, which is a constitutional concept, fair notice as to what the law requires, and makes a number of other arguments as to why the agency's complaint doesn't meet the basic standards of unfairness. One of them, and this is a little bit specific to Wyndham, and it's not going to be true in other data security cases, is a pleading question, right? This seems unimportant because in pleading matters, generally the remedy is, well, you just refile the case. But I think it's actually quite important because it speaks to the general way in which the agency brings enforcement actions, which is the documents that we see on the outside, which is not everything the agency does. They presumably do a lot more legal analysis inside. But what they ultimately produce is what litigators would call thinly pled. It doesn't give you a lot of analysis. And the agency will say, well, you don't see everything that happens inside. And that may be true. It may be that they're working very hard to really think through the unfairness policy statement and Section 5N, which codified it. But the result is we don't see any of that. So my main point about Wyndham is if you're going to have a common law approach, you've got to have analysis. And one of the things that I would like to see come out of Wyndham would be requirements that the agency explain its analysis more, so that in all the cases that settle, we have more to go on, and that in turn would, I think, make other companies more likely to stand up in court and fight because they actually have something to hang their hats on, even though settlements, of course, are not binding upon anyone.
Okay. What do you have to add to this, James or Ryan?
Well, Ryan hasn't said anything yet.
Yes, please.
Well, thanks, Pete. And I would add to what Barron said, agreeing with the importance of having these sort of common law doctrines that allow companies to understand what is a reasonable data security practice. With Wyndham, I suppose that's data point. If the FTC ultimately prevails, that says that Wyndham Boom wasn't enough. But when companies are having to make decisions every day in a variety of contexts about how much to spend on data security, how hard they need to work to protect their consumers, and obviously the answer is not they spend all of their money on data security. They need a body of law and doctrines to look to. And in most contexts, if a company is making a decision about how much to spend or what to do to avert a risk to consumers, it will have this body of law. And in common law, you have tort actions with hundreds of thousands of cases over the years that have been adjudicated, appealed, and so forth. But in the context of the FTC, because of this settlement process, you don't have that. We've also seen a pattern of the FTC settling with companies for conduct that really shouldn't have been the subject of actions in the first place. Now, I should echo what Barron said, that the FTC is not the greatest enemy of freedom as far as the federal regulatory state goes, which is something about as nice of a comment as I can make about the agency. We, the Competitive Enterprise Institute, are broadly skeptical of federal agencies, and we think most of them ought not exist, including the FCC, but many, many more. The FTC, on the other hand, at least seeks to fulfill a legitimate governmental role, protecting consumers from fraudulent misrepresentations and so forth. Whether the proper avenue for doing that is as a federal agency versus private litigants is a separate question, but there's at least a case to be made that certain dispersed harms, you want the FTC to be involved. However, the FTC has settled with companies for engaging in conduct in a way that chills companies from actually doing good things in the future. One example that's a few years old that I think is illustrative of this is the 2002 settlement for about $22 million between the FTC and Google over, there have been several of these settlements, but this one involved an FAQ privacy page on Google's website about users of the Apple Safari browser, the main browser that comes pre-installed with Mac OS. The claim was that that Google said on its FAQ page, not on its privacy policy, but on one of its pages, that if you use Safari, you don't need to opt out of Google's tracking if you want to do so, because by design, the way that Safari was configured, double-click cookies wouldn't work. So this is a form of tracking. It's not particularly harmful, but some consumers don't like it. Now, after Google posted that FAQ, presumably written by some engineers and consulting with product managers, sometime after that, Apple changed the way that Safari worked. So this was a totally independent decision, and as a result, this comment on Google's page became inaccurate for a period of a few months, and this resulted in a $27 million settlement. So, and then there's no evidence here that Google intended to mislead consumers. Not that under the FTC's interpretation under the law, there's no requirement that you intend to deceive. But here, the result of this settlement and others, like the more recent settlement involving a company called Nomi, where the company said you can opt out of this tracking involving mobile devices with Wi-Fi walking around in stores. You can opt out on our website or at retail stores. And people who read it could opt out on the website. A few of them did, but you couldn't opt out in the store. And the concern with both the Safari Google case back in 2012 and this Nomi case is that you start to discourage companies from trying to make accurate representations to consumers, thorough representations about what their privacy policies are. Now, of course, companies are sometimes going to get it wrong. The more you explain to consumers about privacy issues, the more opportunities you have to make a mistake. And in many cases, this will be a mistake that was not unreasonable. That was the product of just a simple flaw or a subsequent change to somebody else's software that you weren't even aware of necessarily. So, the result of this is to make companies want to be less forthright with their consumers. That's not the right message to be sending to firms that are developing these new products. Now, the answer is not no enforcement whatsoever by anyone. But the answer is, as Commissioner Wright in his dissent in the Nomi case explained, for the FTC to focus on using its prosecutorial discretion and focus really on what's material and when deciding whether to bring a case, because not every violation or potential violation is ripe for bringing a complaint. But the FTC seems to be increasingly stretching the bounds of its authority in a way that makes companies just want to clam up, and that's not a good thing for consumer welfare.
Yeah, and so we're headed in the direction of Nomi, but please.
Well, let me just jump in and maybe bring. I mean, this brings, I think, putting what Baron and Ryan said together is, you think about what's where a lot of the problems are with the agency. I think, as you see, we're focusing on the privacy and data security area, and I think that in some ways, I would say, and I don't know if everyone on the panel will agree with me, I think part of the problem here is that it's getting away from this concept of harm, which was so crucial to anchoring it back in the 80s. Materiality is a proxy for harm, right? I mean, and in the Nomi case, the Google Buzz case, or the Google Safari case, that was a consent order violation, so it was a lot easier for the FTC. All they had to say is, you don't have to prove the elements of deception, you just have to prove that you violated the consent order. The consent orders often require you to do lots of things that the law wouldn't do. It's called fencing and relief, so it's a little different there. But Nomi certainly is an issue where consumers had an option to had an ability to opt out on a website. There was another promise that you could opt out in the stores. Somehow that didn't work out. They weren't given notice. My understanding is that a lot of this stuff was in beta testing anyway, so maybe it was an oversight by the firm. They made a promise they didn't keep, but the issue here, materiality, is how ultimately comes down to how important is this to consumers? Did it make a big, was it, and this leads to my bigger point, is that there's a real lack of economic underpinning or empirical underpinning for the FTC's privacy enforcement policy right now. Josh Wright gave a speech at the Chamber of Commerce a couple weeks ago where he talked about this. It's a good speech. The recent Data Broker report that this great sort of shows the promise of the FTC on one hand and it's failing. So the data broker report, they use their 6B authority to go out and get a lot of data from data brokers to find out what they're doing, you know, where, what, and the first half of the report is great. It's very descriptive. We got all this data, and here's what it says. And then you go to the second half of the report where then they start relying on workshop comments, and they spit out hypotheticals. Well, a data broker could use this kind of data on that you go to a sporting goods store and you like to ride a motorcycle to deny you for a job or find out your sexual preferences and then deny employment here. And they spin out the hypotheticals and say, therefore, we recommend legislation X, like a Fair Credit Reporting Act kind of application to data brokers. And it's the FTC at its best and the FTC at its worst. So anyway, I mean, I think that is, to me, the crux of the problem. It fits in with this. We have these consents. Now, I don't differ with Baron in this, but I don't know what, I don't have an easy solution. You can't force firms to litigate. And I mean, you know, I wish sometimes, you know, you wish you could. I know that you wish you could force, and I think with LabMD and Wyndham, both of those kind of on their way to at least some kind of decision. That's good. We're going to get that, and it's a much slower process than it is in antitrust. But of course, antitrust has a 100-year head start, and there's also a private right of action. So you have a I wish we didn't have to have consents, but I don't know what the alternative is. So anyway, I'll turn it over to Ben.
Yes,
and I'm going to run out of time here, so let me try to
go ahead.
say it. So I think there are four things going on here. So the first, and you alluded to this in your original question, and both James and Ryan touched on this. The first is de facto regulation. I mean, the FTC is building a regulatory system that essentially circumvents Mag-Moss. They don't want to do formal rulemaking anymore, but they don't bother.
Magnuson-Moss Act.
Again, the formal rulemaking the FTC was given in 1975, which was amended in 1980.
Yes.
Right, and they're doing it in a number of ways. So they're doing it through reports that are essentially then used as the basis for enforcement actions, and we can talk about that if someone wants to. They're doing it by putting everyone in the industry under sweeping consent decrees that are applied far beyond the original conduct at issue, and that are treated as per se triggers. And this is the key part where the agency can start imposing civil penalties, right? Which is something the agency desperately fought for back in 2010 during the Dodd-Frank reform, because Congress very, very deliberately decided not to give the agency civil penalty authority for first-time violations of Section 5. But if you put everyone under a consent decree, you can get civil penalties, which in turn means you have more leverage. And it creates a cozy relationship between the agency and companies, where the agency functions as the wet nurse, right? If you remember, you know, everyone here has read Atlas Shrugged, right? The wet nurse is the guy, you know, who goes and sits in on Reardon Steel and looks over everything the agency or the company does, and, you know, helps them decide whether it's okay. That's essentially what.
And I was just going to add, I mean, that's because all these orders come with, they're 20-year orders, and almost everyone comes with a monitor requirement and a reporting requirement.
Right, and so the agency isn't literally embedding an employee in companies, but they might as well be, because companies simply, you know, they have to go in, talk to the agency, vet things with them, and it changes everything they do, right? So that's fundamentally changed the nature of this regime, and then the consent decrees are themselves a form of de facto regulation. So that's the first thing that I see going on here. The second thing is, James talked about the reports, some of the reports the FTC has done. He used the particular example of the motorcyclist. So the example, this was front and center in the agency's report about big data and discrimination, and at their workshop, right? And it's in the press release. It's the example they use, and they say, well, you know, a motorcyclist might receive ads. He might like even receiving ads about being engaged in an extreme sport. But he might also find that fact about him is used to discriminate against him for, say, insurance purposes, with no mention of the fact that that's already covered by existing law. And the agency itself has previously interpreted the Fair Credit Reporting Act to say that participation in an extreme sport with the hazardous elements that it involves is covered. Now, there might be ways in which that regime is not adequate. I'm not saying that existing law is necessarily adequate to all problems, but the problem is the agency, it doesn't do the kind of analysis they should be doing of where are the holes in our authority? What is it that we can't adequately deal with today? And what is it that we might need to deal with through targeted legislation? Because the agency has no interest in targeted legislation. The agency has, since 2010, when the last Democratic administration proposed this, and then more recently under this one, has been gunning for getting comprehensive privacy legislation, which means they don't want to bother getting targeted solutions. They want the authority to do anything and even more discretion than they have today. So that's the second thing going on. The third and fourth things are closely related, and you see them in the NOMI case. So in the NOMI case, Commissioner Oldhausen dissents and says this was an abuse of the agency's prosecutorial discretion. In other words, as a policy matter, we shouldn't have brought this case for all the reasons that Ryan mentions earlier. We're going to discourage companies from providing more notice. Same analysis for the Google case. And you can say that the agency is making policy mistakes across the board because they're not thinking about the unintended consequences of regulation. But I would say that that's just the mirror image of the legal mistakes they're making. In other words, when I explain what the policy statements are supposed to entail, what I'm really saying is they're not just there to make the agency's life harder. They're not just legal hoops to jump through or formalities that we should only treat as lawyerly details. They're there to make sure the agency is prioritizing the right things and that they're focusing on, as James says, consumer harm. And so here, it's worth just a moment on the deception policy statement. So the NOMI case has finally sparked a discussion about this problem of the FTC not taking materiality seriously. And it's quite revealing to see reactions to it because you see people in the advocacy community who've clearly never read the deception policy statement. Or if they have read it, they haven't read it very carefully. Or they don't understand the context behind it, which basically, briefly, it was a compromise. Chairman at the time, Jim Miller, wanted to tie deception directly to harm. And there were other people who wanted to do what the agency had been doing since the 1960s, which was to just go after any deception case. And the compromise was, we're going to require materiality, which, as James says, is a proxy for harm. It's a way of saying we know that this was harmful to consumers because it was material to their choice. And if they didn't get the benefit of the bargain, they were hurt by it. But the agency doesn't have to prove it. So it's a more administrable rule than having to prove harm in every case. The problem, if there is one, is twofold. It's one, that the deception policy statement maintained a sort of holdover from the old approach of the 1960s, which is they said, well, we're going to have a presumption of materiality in certain cases. And chief among those was the case of express statements, like the one that Ryan mentioned earlier. If I say X specifically, we presume that's harmful. And if you think about it in context, it makes sense, because at the time what the agency was dealing with were ads and things like warranties. And if you say in an ad something, you can pretty safely assume that's material because the agency's saying it to convince, keep saying the agency, the company's saying it to convince someone to buy the product. Makes sense to presume it's material. But today, the express statements we're dealing with include things like privacy policies and help pages and FAQs and things that are being provided sometimes because they're required by California law, right? Or because the company is under strong pressure to do so, or because they just want to answer a single question, right? The point is, it's time to revisit that presumption that everything that you say expressly is material. Right? That may not make sense anymore for some kinds of express statements. But even if we don't, what's really important is that the old joke among lawyers about strict scrutiny is it's strict in theory and fatal in fact. In other words, you can never win on a strict scrutiny case defending a restriction on free speech. Well, similarly here, the presumption of materiality has really become just an absolute per se rule. Because the agency's made clear, and NOMI makes this pretty abundantly clear, that when they say something is presumed to be material, that's just game over. They're not going to consider other evidence because they don't weigh anything because they're not actually facing a challenge in court.
And James has a comment. Yes.
No, I want to tie into what Darren is saying, and I think that this, since we kind of got into the weeds here in NOMI, I mean this goes to the lack of economic underpinning. So I think if sort of NOMI, the materiality is satisfied, if you think that notice of tracking in store and the ability to opt out in store, when there's an ability to opt out on the website, actually impacts consumers, their desire to go into those stores. Now, hey, that may be the case. It may be that, had I been able to opt out, I wouldn't have gone into Nordstrom's because they were tracking me. But the thing is, we don't know, and it's not just here. this goes kind of to the heart. We don't really know, and I say we, if, you know, the FTC does not really know how consumers trade off privacy, tracking, etc., for other things, like, you know, free stuff, for ads they like. You know, some people really don't like to be tracked, some people don't care. We see reveal preference all the time. Now, so I think, to me, the NOMI case is a larger, it's sort of, you know, a larger indication of this lack of empirical underpinning for the entire privacy endeavor.
And I just want to mention, before we move on from NOMI, we didn't print this out today, but we have a long comment that we filed on the NOMI settlement. It's called Dark Side of INRI NOMI. It's easy to find if you just Google Dark Side and NOMI.
Yes. Baron's got to leave in a couple of minutes here, but I'm going to ask the question that I think is most practical of the panelists. Among the 3 or even 5 things you would recommend that both the FTC and Congress can do to right this ship, to bring us on a course of a properly limited role for FTC, what would your recommendations be? Especially specifics legislatively, if you have any.
If you don't mind if I take that and then leave.
Yeah.
So the first 2 things are procedural. One, Congress has the GAO that exists to advise the lawmakers. We need a GAO study on all these problems, right? That could be done in the course of 6 months. It could advise Congress on some of the details of reform, and you'd have someone other than me and our band of experts whose word to take for all of this. Second, related to that, I would encourage everyone to think about the model of the Antitrust Modernization Commission, which was set up by Congress during the Bush administration, to think about how to change the antitrust laws. You could take a similar model for not just functional, structural changes to the FTC, but to how to deal with privacy law and data security. Right? We've called for that before, a Privacy Law Modernization Commission, which you might think of it a little more broadly as consumer protection in the digital age, focused more generally on consumer protection, especially with regards to changing technologies. And again, the point would be, even more so, it would allow Congress to get specific recommendations on how to change some of these thorny process points that are really hard for Congress to fix. But as to specifics, I think the things that have to happen, so some of this can be done inside the agency, but it's either going to require pressure from Congress, or to be permanent, it's going to have to be done legislatively. And that would be, so reforming a lot of the dynamics around the investigation process, the settlement process, could make a very big difference in changing the model so that at least some companies litigate, so you don't get every single case settling. That would help enormously. And I've already mentioned that one of the problems is there is no set standard today for settlements. So we need something that is a higher standard than 5B, such that every time the FTC wants to settle, they've got to explain to some degree why they want to do so. There are some specific things about materiality that I would put into statute. It's worth noting again that the unfairness policy statement was codified in 1994. The deception policy statement never has been. The agency says it's not binding upon them. I think it needs to be slightly tweaked, just as the 1994 edition of Section 5N slightly tweaked the unfairness policy statement to make sure that the agency didn't just assert public policy as the basis for declaring something unfair. So all that could be done by Congress, but there's another thing we haven't talked about today, which is advocacy work. So it's often thought of that the agency has 2 functions and 3 parts. Competition and consumer protection, each of which has a bureau, and then there's this Bureau of Economics that hangs out and advises the Bureau of Competition. So some of the changes I'd like to see would mean having the Bureau of Economics advise the Bureau of Consumer Protection more. That would be great. But I also think that there's a problem today that the advocacy function of the agency is thought of being just a subset of what the Bureau of Competition should be doing. I think that's a problem. I think the agency should be doing a lot more advocacy work, and it shouldn't just be thinking of it as bringing lawsuits. It shouldn't just be another kind of function. And that's going to happen a lot more now that the agency just won this big decision in North Carolina Board of Dentists, where the Supreme Court said that if a state creates a body that is not only a state body, but is in fact used by private actors to cartelize an industry, such as dentists barring hygienists from cleaning teeth, that the agency can bring an antitrust lawsuit against them. I think that's good. The agency should be doing more suits like that, but they shouldn't just be doing that. they should be doing regulatory filings and research, and they shouldn't just be waiting until a regulator or a state legislator asks for input. They should be filing in precisely those regulatory bodies that are captured by existing special interests. The Taxi Cab Commission that is owned by the taxi cab industry that is trying to shut down Uber, that doesn't want to hear what the Federal Trade Commission thinks. And apparently, as James educated the other day, the reason the agency has this rule about only intervening and providing comments when asked is because in the 1990s, some congressmen thought the agency was getting too big for its breeches and was meddling where it wasn't wanted. And that's a case where I think it should be meddling. We should have something a little closer to what the Korean FTC does, which is in Korea, the FTC in Korea actually functions a little bit like OIRA here. They have to sign off on every regulation in the government. I kind of like that because you get economists weighing costs and benefits and saying something, whether something was good, but at a minimum, just letting the FTC weigh in and just providing an opinion on a state law or a state regulation, like barring Tesla from selling directly to consumers. They've been doing some of that at the FTC recently, did a lot more of that back in 2001 and 2004. That would be a good thing.
Okay.
I'll leave it at that.
What are your opinions, Ryan?
I agree with all that Barron said. A couple of other ideas. We talked about the overbreadth of these consent orders. This is something that Congress could address legislatively. So, for instance, when this big company with hundreds of products makes an actual mistake or engages in deception that's material, for the first time the FTC comes in for violation, and the result is a consent order which will have language like, for 20 years this company shall not make any false statements about its privacy practices, period. In general, in any context, any violation will trigger civil penalties. When you have this fencing in relief that's so broad, these orders shouldn't be enforceable. The FTC shouldn't be allowed to enter into things where there is this degree of breadth. How you actually get the language that is a legislative matter is obviously a challenge. A related issue is the over-deterrence of these violations of these consent orders, which comes in, which we witnessed in Google Buzz, for instance, after there was this multi-million-dollar settlement, because Google was previously subject to one of these very broad consent orders. You had a class action suit that piggybacked off the Buzz settlement. I'd like to see that one of the FTC does in fact get civil penalties for a specific type of conduct that has some sort of a preemptive effect that perhaps even preempts class actions brought under state law. And it's not as if this money is actually going to consumers when Google settles, for instance, with the class action context. What happened there was that the class action lawyers got millions of dollars, and then many more millions of dollars were paid by Google as part of the settlement, as part of a Cypre award to all of these groups that lobby for giving the FTC more power to police privacy. So that's a situation that doesn't benefit consumers at all. It actually hurts them by probably helping groups that are working against their interest, even though they proclaim otherwise. And it deters Google from doing something that it was already punished for doing in the first place. So I think those two solutions, in addition to what Barron suggested, are worth exploring.
Yeah, definitely. What would you add, James?
First, let me say something. I know we're running out of time. I mean, I know we spent almost the entire time talking about the FTC, its consumer protection, especially its privacy area, where I think it's biggest problems. But as Barron alluded to in his opening remarks, you know, I spent 8 years at the FTC as well, and I would not want to leave the impression that I'm here to beat up the FTC. I think it's a great agency. I think people there are fantastically committed to what they do, and they differ on some policy areas which we highlighted here. But of course, what we've highlighted here is kind of a small part in general of what they do. And one area, the other side of the house, where I think they deserve a lot of credit would be the antitrust side. You know, and I would just say that again, Barron talked about the North Carolina dental case, where the FTC. I mean, and this is a long bipartisan pedigree for the most part since the '80s. The FTC has been extraordinarily active at saying, what if the biggest impediment to competition was often the government, right? And so there are a lot of, and this is antitrust law is largely a bipartisan endeavor. There, at the margins, you disagree, but this has been an area where the FTC has been very successful over a period of 30, 40 years, pushing back various exemptions to the antitrust laws. The Noor-Pennington doctrine, which has to do with lobbying, using courts and legislative process to thwart competition. The state action doctrine, which was front and center in the North Carolina dental case, where there's self-interested licensing boards who are using their power. You know, I'm a dentist 360 days of the year, but 5 days a year I put on my North Carolina regulatory hat, and then I want to keep teeth whiteners away from competing with me, so I'll do something there. You know, that's all over that sort of thing's all over the place. The FTC has been really, really instrumental at picking, not only pushing, you know, picking cases when there are 5 or 6 really good cases where the FTC has made, you know, going to the Supreme Court where they've made precedent, has been very helpful to consumers. But I would just differ with Barron. It's really easy since he's not here now. But I would not be nearly as critical with Barron on the advocacy side of things, partially because I used to run the Office of Policy Planning, which was in charge of advocacy during the time he's criticizing. You know, but leaving that aside, I think that, you know, advocacy sort of waxes and wanes a little bit. But again, it's fairly bipartisan, especially since when Tim Muris came in 2001 and kind of reinvigorated the advocacy program. It's really been fairly bipartisan, even when, you know, when John Leibowitz was chairman, and now with the chairwoman Ramirez. Advocacy has been this area. Again, there's some different, you know, a Democratic commission may prefer to not target some areas that a Republican commission would, but for the most part, I think that, again, it shows that why antitrust is largely a bipartisan endeavor, is that, you know, most people agree that in both stripes that there are some areas of where state restrictions on competition are just bad for consumers, and I think really the advocacy function, if you went back and looked at the data, has been about, probably been about fairly, maybe it's declined a little, but not a lot, and maybe it's because there's not as much low-hanging fruit as there was. So I just wanted to say that before, you know, I didn't want anyone to leave the, I know we, you know, leave this thinking that I think, you know, bad things about the FTC. I actually think that it's a great agency. Just the privacy areas where it probably needs the most help. And, you know, going to the big question here is, you know, what sort of legislative reforms. Maybe I'm a little contrarian here, but I know, and of course we're here at Capitol Hill, and I'm supposed to say, yes, here's what you guys need to go back and tell your bosses to do. I think that, you know, again, at the outset, you know, Barron said he's always criticizing the FTC, but fundamentally he thinks that all the tools are there, and I kind of agree. I think unfairness statement's good, deception statement's good. It's just holding them more to these ideas, and I think, again, you know, maybe because I'm an economist, maybe I show my bias here, but I think, and I don't think you can do this legislatively, but except from the oversight function, is to make sure that there's more economic input into the consumer protection side of things, and especially, and I don't really mean, and really mostly on the privacy and data security side. I mean, I think that's the area where the FTC is most visible, where its actions have the have possibly large churn effects. One thing we didn't talk about, these 20-year orders. Here's an example, quick example. Facebook buys WhatsApp. Okay, so Facebook's under an order, 20-year order. So they buy WhatsApp, and why do these big companies buy up these little companies? Well, for data, right? I mean, so this, you know, why does Google buy Waze, right? I mean, you get that because you want to put all this data together to come up with even richer functionality, even better predictions. That's good for consumers. I think it is. But these orders, what went along with the FTC with absolutely no problems clearing the merger because there are no competitive issues, is a scolding letter from the Bureau of Consumer Protection reminding Facebook that they're under order, and that so if that means now that WhatsApp's part of Facebook, if WhatsApp's going to merge their data with Facebook, they have to get opt-in consent from all their users, right? And so what does that do to the value of merger? You know, so who's better at thinking about how to combine data sets and software and functionality going forward? The FTC and the, you know, Division of Privacy and Information Protection, or the people in Silicon Valley who are actually doing this, right? And so I think that's something to think about. Again, legislative fix, I don't think so, but oversight function, absolutely. Look, you know, press for more economic rigor in the privacy and data security area.
Yeah. 30 seconds I'll take for a legislative agenda. 1. Make the federal government a model in response to data breaches that other companies can follow. Senator Collins has introduced legislation to help coordinate federal data breach responses across departments. 2, make sure that through a policy rider in the appropriations process, the FTC is directed to not only follow the fair notice doctrine so that companies know when advice is being given that's binding, but also compel the FTC to direct more resources into the Bureau of Economics so it can inform the consumer side, not just the antitrust side. 3, we have to think about administrative processes of appeal that go outside formal courts so that small businesses especially who find themselves targets of the FTC have a place to go. The model, the Small Business Taxpayer Bill of Rights introduced by Senator Cornyn, which provides alternative dispute resolution processes. Enact that for FTC proceedings and you've got the start of access to justice for businesses who really can't afford it today. I will conclude with that. Do you have questions? We solved all of FTC's problems. What a panel. Thanks so much to my panelists.